A 34-year-old Cree woman in Prince Albert, Saskatchewan, has been paying income tax on her employment income for 11 years. She works as an administrative assistant for a health organization located on reserve land. She files her taxes every April using standard online software. She pays what the software tells her to pay. What nobody told her, not her employer, not the CRA, not her band council's administrative office, not a single person in any professional capacity in 11 years, is that her employment income earned on reserve may be entirely exempt from tax under Section 87. She has been overpaying thousands of dollars annually for over a decade. She is not unusual. Section 87 is misunderstood. The Section 87 tax exemption is one of the most misunderstood, most inconsistently applied, and most unclaimed provisions in the Canadian tax system. And it is one of dozens of federal benefits, programs, and entitlements available specifically to Indigenous Canadians, First Nations, Métis, and Inuit, that go unclaimed every year not because they declined, but because the information never reached them in a form they could act on. The federal government has built and funded programs specifically for Indigenous Canadians covering health, education, housing, and training. The funding exists. The legislation exists. The entitlements are real. Most people designed to be served have never been told the full picture. That is not an information gap. That is the system. To understand why it fails, you need to understand what the programs were built to accomplish and the fundamental contradiction embedded in their design from the beginning. The relationship is defined by constitutional provisions and treaty obligations. Section 91(24) of the Constitution Act 1867 assigned responsibility for Indians and lands reserved to the federal government. Legislation that predates Confederation. Section 91(24) of the Constitution Act 1867 assigned responsibility for Indians and lands reserved for Indians to the federal government, making Ottawa the primary government responsible for programs and services to First Nations people on reserve, establishing the framework ever since. The Indian Act, first passed in 1876 and amended since, is the primary federal legislation governing the lives of registered First Nations people. It defines who is a status Indian, governs band council structures, controls reserve land, and contains the Section 87 tax exemption. The Act has been widely criticized by Indigenous communities and scholars as a colonial instrument that restricted self-determination. The federal programs that exist today emerged from this colonial framework, designed and administered by non-Indigenous government structures, delivered through band councils with varying administrative capacity, and chronically underfunded relative to comparable services. Two failures compound the problem. Administrative fragmentation. Federal Indigenous programs are delivered through multiple departments: Indigenous Services Canada, Crown Indigenous Relations, and Northern Affairs Canada. Health Canada's First Nations and Inuit Health Branch, Employment and Social Development Canada, and others. A single eligible Indigenous Canadian may need to interact with 4 or 5 separate departments. No single point of contact exists to help an individual understand their complete entitlement across all programs. Underfunding and inconsistent delivery. Programs funded in some communities are underfunded or non-functional in others. A health benefit in Ontario may not be accessible in the same way in Alberta. Métis and non-status Indigenous people, who often fall outside the Indian Act framework, have historically been excluded from programs that status Indians access. The entitlements exist. The legislation is real. The programs are funded. The gap is a function of administrative complexity and information asymmetry. Decades of policy design place the burden of navigating the system on the people with the least institutional support to do so. Section 87 tax exemption. Section 87 of the Indian Act provides that the personal property of a status Indian located on a reserve is exempt from taxation. Employment income is exempt. For income tax purposes, this means employment income earned by a status Indian on a reserve is exempt from federal and provincial income tax. The exemption sounds straightforward. It is not. The application of Section 87 has been the subject of decades of court decisions and administrative disputes, and the result is a provision that many do not claim because the rules are unclear, and many others claim incorrectly because they misunderstand the scope. Let me walk through the current state of the Section 87 employment income exemption as clearly as the law permits. Documentary style. For employment income to be exempt under Section 87, the income must be situated on a reserve. The CRA and the courts have developed a test. The factors considered include where the work is performed, where the employer is located, where the employee lives, and the nature of the work. In its most straightforward application, a status Indian employed by a band council performing work on reserve, the Section 87 exemption clearly applies. The complexity arises in situations that do not fit this profile. A status Indian who lives off reserve but works on reserve, does the exemption apply? A status Indian who works for a non-Indigenous employer located near but not on a reserve, does the exemption apply? Again, it depends. A status Indian who works for a federal government department delivering services to reserve communities, the CRA has specific positions. Documentary style. The 2011 Supreme Court decision in Bastien Estate v. Canada and Dubé versus Canada provided important guidance on investment income. Documentary style. The 1992 decision in Williams versus Canada established the connecting factors test for unemployment insurance benefits. Documentary style. The 2018 Federal Court of Appeal decision in Canada versus Gillett addressed employment income situations. The case law is extensive and evolving. The 1992 decision in Williams versus Canada established the connecting factors test for unemployment insurance benefits. Documentary style. What this means practically for First Nations people with employment income that may connect to a reserve, do not self-assess. Documentary style. The connecting factors analysis is fact-specific. An Indigenous tax clinic or a tax professional can determine whether your income qualifies. The CRA has published interpretation guides including IT 62R and more recent administrative positions. Documentary style. If you are a status Indian and you believe the Section 87 exemption may apply, the T1 adjustment window allows retroactive claims. The potential recovery is significant. 10 years of unclaimed exemption on substantial income can represent tens of thousands of dollars. Do not leave this unexamined. The Non-Insured Health Benefits Program, the NIHB, is a federal program for First Nations and Inuit. The program covers health benefits not covered by provincial plans, prescription drugs, dental care, vision care, and medical transportation. The dental benefit is particularly significant. Provincial dental coverage for adults is limited, but NIHB provides coverage unavailable to many. Yet, dental benefit underutilization within the NIHB program is documented. Eligible recipients are often unaware of the full scope, who live in communities without accessible dental services, or who have difficulty navigating authorization, are leaving benefits unused. Who is eligible for NIHB? Registered First Nations people, regardless of where they live. Inuit recognized by an organization. The program does not currently cover Métis people generally, though some provinces have agreements for equivalent coverage. How do you access NIHB benefits? For most services, you present your status card or NIHB client identification at the point of service. For prescription drugs, most pharmacies in Canada can direct bill NIHB directly. You present your status card and the pharmacist confirms. For dental services, dentists can direct bill NIHB. Confirm with your dentist's office that they bill NIHB before your appointment. Medical transportation under NIHB covers the cost of travel to access necessary medical services when not available in your community. This is a significant benefit for remote and northern communities who must travel for specialist care, surgery, or other services. The benefit covers transportation costs, meals, and accommodation in many circumstances. Contact the regional NIHB offices for guidance. Medical transportation under NIHB covers the cost of travel to access medically necessary services when those services are not available locally. This is a significant benefit for remote and northern communities who must travel for specialist care, surgery, or other services. The benefit covers transportation costs, meals, and accommodation in many circumstances. Contact the regional NIHB offices for guidance. If you have been paying out of pocket for medications or dental work, you may be entitled to them at no cost. Contact NIHB directly. Post-secondary education funding for First Nations students is one of the most discussed and most controversial federal programs. The Post-Secondary Student Support Program, the PSSSB, provides funding for tuition, books, travel, and living allowances. The program funds tuition, books, supplies, travel, and living allowances. It is not administered directly by the federal government. It flows through band councils. The federal government provides block funding, and bands determine how to allocate it among eligible students. The result is significant variation. Some bands fully fund all students. Others operate wait lists due to limited allocations. Documentary style. Chronic underfunding is a documented failure. The government capped annual increases for decades, serving a declining proportion of students. Reforms have been promised, but the imbalance persists. Apply early and apply through your band council education department. Documentary style. Contact your education department before the deadline to understand what is available and what the timeline looks like. Documentary style. Beyond PSSSB, the Inspire organization provides bursaries and scholarships to First Nations, Métis, and Inuit students. Documentary style. Inspire is open to all Indigenous students, not just those with status. Application windows typically open in the fall. Documentary style. Many universities have Indigenous bursary programs separate from federal funding. Contact the Student Services Office at your institution. Documentary style. Every province has some form of Indigenous post-secondary support. Contact your provincial ministry for specifics. Documentary style. Jordan's principle ensures that First Nations children access the supports they need when they need them, without jurisdictional delay. Documentary style. Named after Jordan River Anderson, a child who spent years in hospital while governments disputed who should pay. Jordan died in 2005. Documentary style. Parliament unanimously passed a motion in 2007. The Human Rights Tribunal issued landmark orders requiring full implementation. Documentary style. Under the principle, the government of first contact pays for the service immediately and resolves jurisdictional issues afterward. Documentary style. The range is broad. Specialized equipment, therapeutic services, tutors, specialized learning materials, and mental health services. Documentary style. Jordan's principle fills gaps when existing programs are insufficient. For urgent requests, same-day responses are available. Documentary style. First Nations families with children who have health or developmental needs should ask specifically about Jordan's principle. Documentary style. Métis Canadians occupy a distinct position. Historically excluded, they have fought to establish recognition of their distinct rights. Documentary style. The 2003 Pali decision and the 2016 Daniels decision confirmed Métis and non-status Indians fall within federal jurisdiction. Documentary style. In 2019, the federal government began entering into new fiscal arrangements with Métis Nation governing bodies for health and housing. Documentary style. In Ontario, the Métis Nation of Ontario delivers a range of programs for registered MNO members, including health and housing supports. Documentary style. In Alberta, the Métis Nation of Alberta delivers student bursaries, housing programs, and employment training for its members. Documentary style. In Saskatchewan, the Métis Nation of Saskatchewan delivers programs through its affiliate locals across the province. Documentary style. In Manitoba, the Manitoba Métis Federation delivers education bursaries, housing assistance, and cultural programs for registered members. Documentary style. The critical step is registering with your provincial Métis governing body. Registration is the gateway to Métis-specific programs. Documentary style. The Indigenous Skills and Employment Training Program, the ISCT, provides funding for training services to First Nations, Métis, and Inuit. Documentary style. The program expanded to include all Indigenous Canadians regardless of status. ISET funding flows to 85 Indigenous-led organizations. Documentary style. These organizations provide counseling, skills assessment, training funding, and job placement support. Documentary style. Many ISCT organizations provide wraparound supports like childcare and transportation to remove barriers to training participation. Documentary style. Apprenticeship incentive grants are available to all Indigenous Canadians who enter Red Seal trade apprenticeships. Documentary style. The First Nations and Inuit Summer Work Experience Program provides wage subsidies to employers. Specifically ask potential employers about it. Documentary style. Housing is one of the most significant areas of need. On-reserve housing is funded through band councils. Documentary style. For those living off reserve, Several federal programs like the National Housing Co-Investment Fund provide construction support. Documentary style. The Urban, Rural, and Northern Indigenous Housing Strategy is the largest federal investment in Indigenous housing for those off reserve. Documentary style. If you are an Indigenous person living off reserve and facing housing challenges, contact your local Indigenous Friendship Center. Friendship centers across Canada provide navigation support and referrals to housing programs, emergency shelter, and rental assistance. Whether you are a First Nations, Métis, or Inuit person who has never reviewed your full benefit entitlement, here is exactly what you need to do. If you are a status Indian with employment income that may connect to a reserve, get a Section 87 assessment. Contact an Indigenous tax clinic. Do not rely on general tax software or a general tax preparer who may not know the connecting factors test. Retroactive recovery justifies the investment. If you are a registered First Nations or Inuit person, contact Health Canada's NIHB program. Confirm your eligibility and use your benefits. If you have been paying out of pocket for covered services, request retroactive reimbursement for recent claims. The NIHB program has a process. If you are a First Nations student seeking post-secondary funding, apply to your Band Council Education Department immediately. Funding is limited. Simultaneously apply to Inspire's Building Brighter Futures bursary program at INDspire.ca. Contact the Student Services Office at your institution. If you are a First Nations parent of a child with needs, ask about Jordan's Principle. Contact your band's health director or social worker. If they cannot navigate the Jordan's Principle application with you, call Indigenous Services Canada directly at 1-855 JP Child. If you are Métis, register with your provincial Métis governing body. Registration is the gateway to Métis-specific programs in every province. Bring documentation of your Métis ancestry. The registration process requires evidence of Métis heritage and community connection. If you are seeking employment or skills training, contact your nearest ISCT-funded Indigenous Employment Center. Their services are free. In urban centers, the local Indigenous Friendship Center can direct you. If you are facing housing challenges, contact your Friendship Center. Friendship centers are the most consistent access point for Indigenous people living off reserve to navigate the full range of federal and provincial programs. If your situation is complex, contact the First Nations Tax Commission, a legal clinic with Indigenous law expertise, or Aboriginal legal services. Indigenous legal clinics exist in most major Canadian cities and provide free legal advice on tax matters, benefits, housing, and other issues. The programs are real. The entitlements are documented. The federal government has made commitments and allocated funding across every area. The gap between what is available and what is being received is not insurmountable. It closes one informed conversation at a time. The Cree woman in Prince Albert filed a T1 adjustment after a colleague mentioned Section 87 at a staff meeting. An Indigenous tax clinic confirmed that her employment income qualified for the exemption. She recovered 8 years of federal and provincial income tax. The amount was more than she had saved in her entire working life to that point. She found out at a staff meeting, not from the CRA, not from her employer, not from her band's administrative office, from a colleague who happened to know. The federal government had her data. The Section 87 exemption has been in the Indian Act since 1951. Nobody sent a letter. They never do. If this video reached you, share it with your community, your family, your coworkers. These programs were built for specific people. Most of those people have never been told in plain language what they are entitled to, how to access it, and what happens if they do not. That changes one conversation at a time. This was the conversation. The programs are real. The entitlements are real. The federal government has allocated funding. Reach out to confirmed organizations today to explore your full entitlement. Contact your band council, your provincial governing body, or an Indigenous tax professional to begin the process. You are entitled to support. Information is power. Taking the first step towards claiming your benefits is an act of self-determination and community strength. The journey to recovering what is yours begins today. Do not let these entitlements remain unclaimed any longer. Success is within reach. Together, we can close the gap. Share this knowledge widely. Ensure every member of our community knows their worth and their rights. The legislation is real. The funding is real. The commitment to Indigenous Canadians must be realized through informed action and awareness. You have the right to access every federal benefit, program, and entitlement available to you. Start your assessment today and secure your future. Your local Indigenous support network is ready to help you navigate the system. Reach out to a friendship center near you. You are not alone. Fairness and justice are documented. The Section 87 exemption and other federal programs are part of the legal commitments made to you. A bright future is paved with informed conversations. Share this video and help others take the first step on the road to their entitlements. This is your guide. This is your entitlement. That changes one conversation at a time. Empower your family and community. This was the conversation. Unclaimed Rights, a comprehensive guide to Indigenous benefits in Canada. Closing the gap, one informed step at a time.